Hello everyone. This is going to be a lecture about the Human Rights Act. So I'm going to tell you about the principal features of the Human Rights Act and how it functions. I'm going to talk about how the European Convention on Human Rights is interpreted. I'll also tell you about parties which under Section 7 of the same have standing, as in to say they can actually argue their case in court, and about the liability of public authorities under Section 6 if they are not acting in accordance with the Convention, and also about how the courts interpret the statute that's in relation to Sections 3 and 4. So the Human Rights Act was passed in 1998, took effect in 1999 in North Britain, in 2000 in South Britain, and in Northern Ireland. So it was many moons ago now, because the white paper, when it came out, had a picture of a very youthful, pixie-faced Tony Blair on the front. So looking back to the jurisprudence of the European Court of Human Rights, Lord Derry Irvine was the Lord Chancellor at the time, Tony Blair's pupil master, when Blair had been a pupil, as in a trainee barrister. And so Lord Irvine had something to say about it. A UK court determining a question which has arisen in connection with the convention right must take into account any judgment or decision of the European Court of Human Rights. Close quotation. So they have to take it into account. They don't have to be rigidly bound by it. They could take it into account, say that's not entirely pertinent here, or for some other very good reason why they're not going to follow its jurisprudence. Jurisprudence is like the philosophy of the law. Okay, so there's a question about whether there's comity or dialogue in relation to the European Convention on Human Rights. Comity is like community. We said the comity of nations. Is it just being linked somehow, or is there? Well, I can't think of another synonym for dialogue. Conversation between two systems of law which somewhat overlap. Intercourse. Okay, bit of innuendo really spices up any lecture. There was an important case here, R. Uller and Special Adjudicator 2004. Now, I don't thrash out all the cases I cite because these talks are going to take half an hour and it would just be too lengthy. Look it up. Lord Bingham, the late Lord Bingham, sat on this case, and this is what he had to say in relation to the said case. The duty of national courts is to keep pace with Strasbourg jurisprudence, no more, but certainly no less. So Strasbourg, remember, is the site of the European Court of Human Rights. It's not an EU court. The EU court, that's the Court of Justice of the European Union, is based in Luxembourg. I know it's something which really flummoxes many people because the European Parliament is in Strasbourg half the time. So in R and Horncastle 2009, the UK Supreme Court said that there's dialogue between them and indeed the European Court of Human Rights. Don't imagine there's enmity between them. There's a great sense of collegiality between justices of both courts. Okay, so someone has a case going there because they've run out of remedies in their national system. And so this claimant has to have standing, or locus standi, like a place to stand in Latin. So under Section 7, it says, any person who claims that a public authority has acted unlawfully may bring proceedings, but only if he is a victim. Can't bring on behalf of someone else. Incidentally, in all these statutes, be it understood that the masculine pronouns he, him, his shall also import the feminine. It could be she, her, or hers. Now, sometimes, being very PC, I'll just use the feminine pronoun, and be it understood, this could mean males as well. Because some people use the ungrammatical they, just to try and be gender neutral. It, why not he stroke she, or brackets S-H-E, so it could be he or she. Anyway, so under Section 7.7, it says the victim is the same as defined by Article 34 of the European Convention on Human Rights. So Article 34 says any person, which could be a non-governmental organisation, could be a group of people, claims to be a victim. It doesn't have to be just an individual. So there's a test about this, and that relates to class and Germany 1978, people who are directly affected. You can't be indirectly affected. You don't have locus standi. So now the thing is, I'm saying it the English style, class and Germany, but as it's a European case and it was a Roman law system, should I say class v Germany? Not sure. So sorry for sounding Northern English, class, but I think that's how it's pronounced, as it's a German surname. Okay, let's look at how defendants are treated with under the Human Rights Act, Section 6, all the foregoing sections of the Human Rights Act, incidentally. So Section 6.1 says the following: that it is unlawful for a public body to act in a way which is incompatible with a convention right, unless it has a defence under Section 6.2. So there are some reasons why they don't have to act in a way that they can act a way which is incompatible. So some people say, well, is there a leeway? Is there a margin in between? There's compatible over here, there's incompatible over here, and in between them there's a bit of a gap, which is not compatible, but it's not incompatible either. That's a really lawyery way to lawyer way out of it. Okay, so what counts as being a public body, public authority, as per the Human Rights Act? Well, this was examined. So Rights Brought Home was the Labour government's white paper in 1997, as in their proposal for legislation, sort of a discussion document before they actually drafted the bill. And that was weeks after they were elected, so it was of huge importance to them. Bear in mind, Labour had been out of office for 18 years. You might have thought they had more urgent priorities. And in the white paper, it supplies many examples of core public authorities. So Section 6.3 of the Human Rights Act lists them, but includes courts of law. So such a thing called horizontal application. Now, some authorities are hybrid authorities. Under Section 6.3, it's saying any person certain of whose functions are of a public nature. Close quotation. So you might be a person who has some public functions, some private functions, but if at least some of your functions are public, then you are a public body. And by person, it doesn't have to be just an individual. It could, of course, be organisation. So Section 6.5, it says, in relation to a particular act or person is not a public authority by virtue of subsection 3b if the nature of the act is private. Close quotation. So you could be a public authority, but the particular act you're carrying out is private. Therefore, in relation to that, the human rights will not operate to say, well, this was incompatible with the European Convention on Human Rights. Therefore, bad boy. Okay. Anyway, so according to the Human Rights Act, there is liability for public authorities. Remember, I said that these core public authorities, and they're liable in every conceivable situation where there's a breach of their human rights obligations. Whereas there's certain hybrid public authorities, and they are only liable in the execution of their public function, not in the execution of their non-public function or possibly private function. So what there was the Aston Cantlow case, and Lord Nichols, Law Lord, had to consider what defines a public authority. So that they have special powers conferred upon them. All right, making them a public authority. They have to be democratically accountable to be a public authority. They must be funded by the taxpayer. They must be supposed to act in the public interest. That means doing what's good for the public. And they have to have a statutory constitution, as in a statute has created them. So, but like the Army, the Navy, the Air Force, the police, prisons, really any government department, the Highways Agency, lots of next steps agencies, things like the Passport Office, which comes under the remit of the Home Office, hospitals, state schools, universities, independent schools, we're not sure. Well, some of them are created by statute, they're not publicly funded, usually. Maybe have a bit of public funding. Not very democratically accountable, even indirectly, so I think not. Okay, so looking on to the hybrid authorities, this is the Aston Cantlow case. So it said, all right, you are publicly funded, you have a statute granted you your power to carry out your activities, and you are acting in loco governmentalis, and what else? Yes, the service that you provide is for the public. And usually they don't charge Now, like the NHS, they do charge for certain things, for some dental work, for some prescriptions, but broadly speaking, these public authorities don't charge people. Okay, so hybrids. So let's look into some of the case law. So under the Human Rights Act, there is liability for some of these. There was Popular Housing Association and Donahue in 2011. So it was held to be closely interlinked with the state. Or there was R. Weaver and London against London and Quadrant Housing Trust in 2009. Now, there were cases where so-called public bodies were found not to be liable. For instance, R. Heather and Leonard Cheshire Foundation, that's in 2002, or YL and Birmingham 2007, because the services for the public had been contracted out, so that it wasn't directly the public body was doing it. So, if you are liable under the Human Rights Act, Section 6.1, this is when the Human Rights Act has done something, the public authority has done something which is illegal. Because under domestic law, you have to act in a way which is not incompatible with the Human Rights Act. However, there is an exemption. If British legislation obliged you or permitted you to act in a way which is incompatible with Section 6.2. Okay, so let's look into this defence that's built into the Human Rights Act. So Section 6.2, this is something that public bodies can avail themselves, unless, of course, the court says that the court interprets the legislation and says you're still incompatible in such a way that it breached the rights conferred by the European Convention of Human Rights too fundamentally. Whew, it's all tricky. The exegesis of the Human Rights Act. Semantics, eh? Anyway, so Section 3.1 of the Human Rights Act says the following: so far as it is possible to do so, legislation must be read and given effect in a way which is compatible with convention rights. Close quotation. Convention rights as in rights derived from the European Convention on Human Rights. But remember those golden words, so far as it is possible to do so. As in, there might be a situation where it is not possible to do so, or you can only do so part of the way, so far as it is possible to do so. That's the operative phrase. Let's go back to R and A, CSH, 2001. Okay, under Section 41 of the Youth Justice and Criminal Evidence Act in 1999, there was a rule about what evidence in rape cases was admissible. And Article 6 of the Human Rights Act says everybody's entitled to a fair trial. So Lord Hope and Lord Stein seem to disagree on this one. So Lord Stein was looking at Section 3 of the Human Rights Act, and he believed that there was a clear interpretive duty. And so there's these declaration of incompatibility, which the House of Lords could issue, or now the Supreme Court, saying that the public body has acted in a way which is incompatible with the Human Rights Act, or the European Convention of Human Rights, or indeed that legislation is incompatible with it. So this is what Lord Stein said. In accordance with the will of Parliament, as reflected in Section 3, it will sometimes be necessary to adopt an interpretation which may appear linguistically strained. Close quotation. So you're putting a heavier burden on the English language than its semantics can bear, right? Tying yourselves in knots, playing word games, is a bit like this sort of this hair splitting between, is it not compatible but not incompatible, just not compatible? You know, the little gap in between, or is that not a real distinction? All right, so Lord Hope did not see eye to eye with his colleague, and he said, in relation to the same case, the rule of construction that Section 3 lays down is quite unlike any previous rule of statutory interpretation. Compatibility with convention rights is the sole guiding principle. But the rule is only a rule of interpretation. It does not entitle judges to act as legislators. Close quotation. When he uses the word construction, he doesn't mean building things. To construe, as in to interpret. Now, often from one language to another is a real classicist, because you have to construe things from Latin. Right, but it's how we're going to transpose these rights which are on paper into reality, this decision. Is this evidence admissible or not? And that's the kind of issue you're trying to hammer out when you're interpreting the Human Rights Act and the European Convention on Human Rights and other statutes, and indeed the actions of public authorities. So back to what Lord Hope was saying. So the judges have to exercise some discretion in interpreting things, but they can't be making law in the legislative fashion. Right, that's for Parliament to do. This is where he disagreed with Lord Stein, and he felt Lord Stein was straying into the political arena. Now, let's look at incompatibility as per Section 4 of the Human Rights Act. There was Bellinger and Bellinger, a 2003 case, and it pertained to the Matrimonial Causes Act of 1973, and it was about institutional competence. Is this body allowed to adjudicate or act on this area of activity or not? Or maybe that's beyond their remit. So they were found to be incompatible there. Are Ray S. and Ray W. 2002. This was as per the Child Care Act. Certain care orders. Children who are very badly treated by their parents can be taken away from their parents and put into care. In the old days, we used to call that an orphanage. So the court said you have to watch out for amendment legislation. So what is the approach at the moment? Well, Gadian and Godden Mendoza 2004 gave us some idea of what the situation is now. This was a case which involved the Rent Act 1977, and one spouse has died, the other one is still alive. What are the rent arrangements? Can they be changed? And anyway, so the court said that the change went with the grain of legislation. You've got to see direction of challenge. Sometimes we see which way the judiciary is tending on an issue. Deciding this is within the court's competence, it was found. So in this Gadian case, Lord Nichols had something else to add about this. He said the interpretive obligation decreed by Section 3 is of an unusual and far-reaching character. Section 3 may require the court to depart from the intention of Parliament which enacted the legislation. The question of difficulty is how far and in what circumstances. Section 3 requires the court to depart from the intention of the enacting Parliament. Close quotation. Now, that is fascinating, because previously judges have often said that they resiled from interfering with the legislative competence of Parliament. The judges themselves mustn't make law. I mean, there are judges who say they can make law, but even then they would be circumspect about doing it, just as they say it'd be wrong for politicians to try and act as judges. So Lord Nichols says, that sometimes you can go against what Parliament wanted to do when it was legislating, because remember, statutory interpretation, often they'll look back at the mischief rule. This statute, it was passed in order to cure what mischief was it, okay? And what was said in the debates at the time, all right, this is the purpose of the act, and therefore we'll interpret it purposefully and try to make the will of Parliament actually effective. Implement it. And here is Lord Nichols saying that they can go against the will of Parliament. He uses the word intention, but it's the same. And intention is a key notion in law. So again, Lord Nichols is cautious about this, saying that only in a particular situation can the court go against what Parliament wanted when it passed the legislation, and it can only go a little distance from what Parliament wanted, and be careful not to go too far. But it's again, it was almost revolutionary of him to say that, even though this was actually quite guarded. Now, so let's look at the repercussions of Section 4, declarations of incompatibility, a DOI, they often call it, when the Supreme Court would say that a public body or indeed a statute is incompatible with the European Convention on Human Rights. The DOI does not affect the validity, continuing operation or enforcement of a provision. Okay, that's as per Section 4.6 of the Human Rights Act, because remember, there's parliamentary sovereignty. If Parliament clashes with the Supreme Court, Parliament prevails. You might think that's wrong, but that is the situation in the United Kingdom. It's different in other places. In the Republic of Ireland, for example, our Supreme Court can strike down legislation that it says is repugnant to the Irish Constitution. Now, it was readier to do that with legislation which predated the foundation of the independent Irish state in 1921. For instance, Norris in Ireland, 1976, when David Norris, a gay rights campaigner, he brought his case to the Irish Supreme Court, saying the Offences Against the Person Act 1861, which criminalised all homosexual acts, was flying in the face of the Irish Constitution, But actually, the court, though they chose to go against him, they said no, it is compatible with the Irish Constitution. He lost his case, but they also affirmed that legislation which is abhorrent to the Constitution would be declared invalid, but not in this particular case. Anyway, so the ministers and Parliament could amend a law, including Section 10, their power to take remedial action. I could say, all right, well, the court declared this was incompatible with the Human Rights Act, so therefore we'll reverse the decision that was made, or indeed we will amend the legislation that offends the European Convention on Human Rights. So Section 4, Declarations of Incompatibility, they're connected to Section 6.2. Remember, it's under Section 4 of the Human Rights Act that these declarations of incompatibility could be issued. This keeps the statutory defence for the public authority. But it doesn't provide a remedy for a claimant, which might be a deficiency in the legislation. So let's look at the remedial effect of Section 3. So Section 3 can be used. British law is to be interpreted compatibly with the European Convention on Human Rights. And I'm saying British here, not English. There is a difference because this applies to Northern Ireland and Scotland, not just England and Wales. English law, we should say English and Welsh law. Sometimes I'm very broad-minded, let's say Welsh and English. Let's put Wales first for a change. But it's almost invariably called English law. So anyway, there's a defence of the public authority. If a right is violated and they acted unlawfully domestically, then that falls under Section 6.1 of the Human Rights Act, and the claimant would get a remedy according to Section 8 of the Human Rights Act. So things have got to be put right for them. Quite difficult, I know, but I managed to keep it, well, not much over 22 minutes. Well, thank you so much for watching. So please subscribe to my channel and book online lessons with me in law. And that's it. You can see my other channel, George from Ireland, search it on YouTube, or indeed my channel, British Poesy. Toodle pip.